my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I will be discussing one case, and the name of the case is Satvir Singh versus State of Haryana. This case is related to dowry debt that is being provided under section 304B of Indian Penal Code 1860. Section 304B talks about where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was being subject to cruelty or harassment by her husband or by any of the relatives of husband, or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. The explanation of this section is, for the purpose of this subsection, dowry shall have the same meaning as in section 2 of Dowry Prohibition Act 1961. Whoever commits dowry death shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. Now, by looking at the facts of the case, a decision was being passed by Punjab and Haryana High Court, where the court dismissed the appeal that was being preferred by the appellant and upheld the order of conviction and sentence that was being passed by the trial court. The appellant were convicted by the trial court for the offences under section 304B and section 306 of IPC, were sentenced to rigorous imprisonment for 7 years, and under section 306 the rigorous imprisonment is given for a term of not less than 5 years. Now, the issue before the court was whether the trial court and high court was correct in convicting the accused under section 304B of Indian Penal Code. The judgment was laid down by the bench was that while considering all the essential ingredients, the presumption was being made under section 113B of the Evidence Act make it mandatory to operate against the accused. The presumption of causality that arise can be rebutted by the accused. Second, the usage of rebuttable presumption of causality under section 113B of Evidence Act creates a greater responsibility on judges and defense prosecution. Hence, they need to be extra careful during while conducting the criminal trial related to section 304B of IPC. In order to address this situation, the procedure law has some safeguards which merits mentioning hereon. The court observed that the bench also observed that section 304B of IPC does not take a pigeonhole approach in categorizing death as homicidal or suicidal or accidental as was earlier done. The reason for such non-categorization is due to the fact that death occurring otherwise than under normal circumstances can in case be homicidal, suicidal or accidental. However, section 304B of IPC endures to also address 16 of those situations where murders or suicide is being termed as accidental. Therefore, if all the other ingredients of section 304B of IPC are being fulfilled, any death, whether caused by any burns or by bodily injury or occurring otherwise than under normal circumstances, shall, as per the legislative mandate, be called as dowry death, and the woman husband or the relatives of the husband shall be deemed to have caused her death unless proved otherwise. The section clearly specifies that what constitutes the offense of dowry theft, and also identifies the single offender or multiple offenders who has or have caused the dowry theft. Thank you.